To introduce the next panel, Court No-Shows, the Systemic Challenge of Failures to Appear. When we talk about criminal justice reform, when we talk about accuracy in the system, a big topic is bail reform. And the Quattrone Center has been involved in bail reform for quite a while. In 2017, our academic director, Paul Heaton, with our first two fellows, Sandra Mayson, a young Sandra Mayson, and a young Megan Stevenson, released a groundbreaking paper looking at cash bail in Harris County, Texas, and realizing that the downstream consequences of cash bail might actually be increasing crime, and it led to a lot of change in the space. Sandy has continued to be involved in the space, and she's going to be leading a panel that in part stems from a more recent but equally groundbreaking paper that she and Lindsay, Graef and Arlie Oos and Megan Stevenson put together on failures to appear. And so when we look at the system as a system and ask the question, is the system generating the results that we want, gathering that data and really being able to learn from it so that we are really making the changes we want to make, and we're not just taking a belief structure, but actually using data in the system to make actual constructive change is really important and hard to do. And we've got a great panel of people who actually practice in the system, and the blending of practice and research and data analysis is going to make this a fascinating panel. So I'm thrilled to introduce Sandy Mayson, Eleni Belisonzi from the DA's office, Rachel Echemendia from the Defender Association, William Fritze from the DA's office, and Lindsay Graef from Penn's Criminology Department. I did get one request from the last panel to make sure that we're speaking into the mics for folks, so if you pull the mics closer, we'll get great throughput, and thanks very much, and Sandy, please take it away.
Thank you so much, John. It's a pleasure to be here. Thank you all for being here with us this morning. My goal is to speak as little as possible, so I am actually just going to turn it over immediately to Lindsay Graef, who's a PhD candidate here in Penn in the Criminology Department. She will briefly present an overview of this study that we did, and then we'll hear from people who really know how things operate on the ground. Take it away.
Thank you, Sandy. So pretrial policy has really focused so far on defendant failures to appear. And so we have, all of these tools and intensive systems. Whoa, sorry, I cannot see my slide. Okay, we're good. So all of these, tools and institutions that we've built to make sure that defendants show up in court. So we'll make them pay cash bail, supposedly to ensure their appearance, or we might detain them pre-trial if they can't afford to put up that collateral. We've built entire pre-trial services agencies to monitor and supervise people, and we have this whole industry of bail bondsmen who act as headhunters if defendants fail to appear. And the rationale around all of this stuff is that the courts can't work and justice can't be served if defendants don't appear. But the courts also can't work if other people don't show up. So we need judges and juries, we need defense attorneys and prosecutors, we need police officers and victims and other civilian witnesses all to show up and to participate in court proceedings. But the criminal justice literature so far is missing some basic facts on failures to appear from all of these other actors. And so in this paper, we ask how common are these failures to appear by other actors, and what happens to cases when these other people don't show up. So our main data source is docket entries that are entered by the clerks of court. And so this is just a big text field where they basically write a summary of what happened at each hearing. And we can identify failures to appear by searching for keywords in this text field. So you can see an example here. They wrote police officer unavailable. we can catch those keywords and tag it as a police failure to appear. And our main sample is cases from January 2010 to just before the pandemic. We need to exclude diversion cases because those are much more likely to be expunged, and once a case is expunged, we actually don't have this detailed text information, and so we can't see failures to appear for those cases. And then we also have some information on which people are expected to show up for different cases in different hearings. So for example, we have data on the subpoenas that prosecutors send to police officers, and so we can see the specific hearings that they're showing up for. So we start by simply describing the prevalence of non-defendant FTAs, and we find that about 53% of cases will have a police officer, a victim, or another civilian witness fail to appear at least once throughout the course of the case. And this is over twice as many cases as will have a defendant FTA. And you might think, well, maybe this is due to defendants being detained pre-trial. But actually, when we rerun these numbers on just cases where the defendant is released on bail, it doesn't actually change that much. When we break this out by actor, we see that officers, victims, and other civilian witnesses all fail to appear just as often, if not more so, than defendants. And also private attorneys who are paid to appear in court and defend their client, they fail to appear pretty often as well. But of course, so some case types just are less likely to have one of these actors associated with them. And so we might think the numbers that I just showed in the past slide are sort of artificially too low because not every case even has a victim associated with it. And so just as an example of this, we see here domestic violence and property cases are much more likely to have a victim associated with the case, but DUI and drug cases are much less likely to have a victim, and that makes sense. And so what we can do is we have some information from the district attorney's office case management system, and we can see which cases have one of these actors associated with it. And so we're going to say, if there's a victim associated with the case, we think it's likely that they were expected to appear at least once throughout the course of that case. And so we recalculate the FTA rates based on the cases where we know that one of these actors was supposed to show up. And we find that when they're expected to appear, all of these types of actors fail to appear at much higher rates than defendants. For police officers, we also have this detailed information on the subpoenas that prosecutors send. And so what that means is we can see not only the cases that they're associated with, but we can see the exact specific hearings that they're supposed to show up for. And so when we look at hearings where they're supposed to show up, police officers fail to appear about 13% of the time, and that's twice the rate of defendants. So what happens when someone fails to appear in court? Just descriptively, when an officer, a victim, or other witness fails to appear, cases are much more likely to be dismissed or withdrawn. And so here the top bar is showing case outcomes for cases where there's at least one failure to appear by a victim, officer, other civilian witness. And the dark green portion is telling us that those cases are dropped well over 50% of the time. We also estimate the effect of FTAs on case outcomes by running a regression of case dismissal on FTAs, controlling for a bunch of the features of the case, like the defendant's age and criminal history, and even their specific charge down to the subsection in the criminal code. And so the idea is just that we want to compare cases that look as similar as possible on a whole bunch of features, and then see the differences when the one big thing that's changing is whether or not one of these actors failed to appear. And so what this graph is saying is when we look at cases where everyone showed up, those cases are dismissed about 25% of the time. But when a police officer fails to appear, the case is then 15 percentage points more likely to be dismissed or withdrawn. Similarly, when a victim fails to appear, the case is more than twice as likely to be dismissed. And we can use these regressions to look at, kind of weigh the importance of different factors in predicting case outcomes. And we actually find that non-defendant failures to appear are the most important predictive factor of case dismissals. And so these bring up a lot of questions and potential policy implications, and I'm mostly going to leave it here so we have plenty of time for the panel. But a couple big things that we think about in this paper are the importance of addressing logistical barriers for all people to show up in court. Really the grounds for defendant pretrial policies are called into question with some of this, and then trying to think about witness FTA as a regulatory mechanism, and when is this when is someone's non-appearance in the system sort of a helpful signal for us, and when is it a really big problem? So, the end.
Super. Thank you, Lindsay. For people who came into the room during Lindsay's presentation, just a quick recap of the panel and the headline from this study. A big part of the bail reform conversation has been about failures to appear in court, FTAs. The question is, do we need cash bail to get defendants to court? The objection to bail reform, one of the objections is if we don't have cash bail, FTAs will go through the roof, the criminal justice system will grind to a halt. And this study looked at 10 years of data from Philadelphia and asked, are failures to appear a big problem? Are they common? Are they thwarting the administration of justice? The answer was yes, but not defendants' failures to appear. You know who really fails to appear? It's the other actors in the system. So police officers, complainants, even private lawyers. Now we'll turn it over to people who actually work in the system every day. And I hope they'll tell you a bit about whether this data comports with their own experience. Is this what things are like on the ground? If so, to what extent do you guys think failures to appear are a problem as opposed to a helpful functionality in the system? What's your sense of some of the things that drive FTAs? And if you think this is a problem for the systemic operation of the criminal justice system, what should we do about it? We'll start with Eleni.
All right.
Could each of you just reintroduce yourself and briefly describe your role?
Sure. Good morning, everybody. My name is Eleni Belisonzi. I am the chief of the municipal court unit at the Philadelphia District Attorney's Office. So my job as chief of that unit is to oversee the prosecution of just about every misdemeanor trial and felony preliminary hearing in Philadelphia. It is the largest trial unit. It is staffed with our youngest attorneys. It's attorneys that are mostly right out of law school. And as you can imagine, it is a very high volume business. These are attorneys that are in court every single day, either with a misdemeanor trial or a felony preliminary hearing. And because these attorneys are so young, a big part of my job is reviewing with them what happened with their case when they come back from court. So those are called disposition meetings. I go to court as much as I can, but it is impossible to be. I think we have 14 courtrooms a day that we cover, so I obviously cannot be in 14 courtrooms every single day. So that's the importance of the disposition meetings, is I ask the attorneys to come back, tell me what happened with your case. This case did not move forward. This case was dismissed. Why was that? And an incredibly frustrating part of my job is when I go through those dispositions with those attorneys and I see the reasons that so many of our cases are dismissed or that we withdraw those cases is because of failures to appear. Obviously, as a prosecutor, we carry the burden. We have to meet a burden of proof in order to progress our case forward, either the burden of beyond a reasonable doubt at a trial or the burden of prima facie at a preliminary hearing. So if we don't have witnesses that we can call to help us meet that burden, that case is dead in the water. And a big frustration is I think we have to separate police FTAs and civilian witness FTAs. I think that those are two very different problems. Of course, it is also frustrating when the private defense attorney doesn't come, but that's we'll footnote that for another time. But when I'm reviewing cases and I'm looking at a case and I see, okay, this case was dismissed because a police officer didn't come. The next inquiry I have is, well, have they ever come on this case? Have they missed every single hearing of this case, or was it just this last one when the judge says it must be tried today and the police officer isn't here, Commonwealth, I'm throwing out this case? Then I have to do an analysis of what that case was. Is this a very violent case where we need to fix this problem immediately, or is this a situation where that case is not going to be revived due to the nature of the case? Same thing with complaining witnesses. Is this a complaining witness who never came to court? Is this a complaining witness who knew about court and didn't come? Because there's a big distinction in my mind. If we can't prove we ever spoke with a complainant, can we really call that a failure to appear? I'm not 100% sure that person knew about court, versus when the DA has documented in their file, called complaining witness to remind them about court. They told me I'm never coming, click. So we have to kind of do an analysis of what kind of case we're looking at, the danger of that case, how many FTAs were there, who was FTAing, and at what rate. Obviously, it's a very concerning situation when I'm looking at, let's say, an attempted murder preliminary hearing or a gunpoint robbery preliminary hearing, and the police officer has never come. And a police officer is needed for that case. That's a situation where now, I need to reach out to that officer's superior and find out, all right, I need to refile, I need to reinstitute this case. How can I get this officer in? But a big part of the problem is not just that, officers don't come to the courtroom. I know we would like to think that they blew off the case. A big part of the problem is that officers are subpoenaed to so many courtrooms in a day, it is impossible to get them to every courtroom where they need to be. And what I mean by that is this: police officers get paid overtime if they are subpoenaed to court outside of their normal working hours, and they are paid at a much higher rate than if they are subpoenaed during their normal working hours. So the way the system is set up is to try to increase efficiency, I suppose, is to subpoena the police officers as much as we can on the days when they're on day work. The result of that, though, is that some police officers are subpoenaed to 5, 10, I've seen 20 rooms in one day. And it would be impossible for that police officer to attend 20 courtrooms and 20 hearings in the same day. And when you saw the docketed information, so the information of police officer FTA, that's the note from the courtroom. That was the result in the courtroom. But what we don't know is, did that police officer just not show up to the building that day? Was that police officer in another room? What we don't know from the docket is whether or not that police officer just completely blew off that court listing that day, or if they were stuck somewhere else. And that's an incredibly frustrating problem when, you have the volume that Philadelphia does, you have all these courtrooms that are running every single day, these judges that sit with lists and lists and lists, defense attorneys who, private counsel who, in order to make a living, need to have several cases listed a day. We're expecting kind of like the perfect storm that you get everybody that you need into the courtroom at the same time to be able to put up the case. And when I review files and I ask the DA, okay, well, this officer, wasn't here, did you reach out to that officer? And they'll say to me, oh yeah, no, I reached out to the officer. The officer was testifying 3 rooms up, but we couldn't wait any longer because the defense attorney had to leave to another room. That's just a complete breakdown where you have all the actors in the building, but we just can't organize our day enough to get everybody in the same room. So I think when we look at police officer FTAs, there's the category of police officers that, that don't come to court, that for, whatever reason they didn't show up. That needs to be dealt with one way. But I do think that there's a huge organizational and systematic failing in the way that cases are called in Philadelphia that allows for the situation where we have so many people that are all needed in the same exact spot at the same exact time that we can't actually move any cases forward. I will let my other colleague from the DA's office talk about civilian witness, or if he wants to weigh in on police witness, that's fine too. But the other thing I wanted to say too is the technology.
That is the harder topic.
The harder topic, yes. I kicked that one down the road. The technology of not knowing where a police officer is. Right now, police officers check into City Hall, so we know that they have checked in, but we don't know where they are, which is absurd in a day and age where we all have cell phones, we all have trackers. I mean, the analogy I've used with the police department is when I order ramen for dinner, I can see the ramen getting made, I can see the ramen coming down my street, I can go outside and get my ramen. Like, why is it that I don't know what room a police officer is when I know where my ramen is? It just seems absurd to me that we should be able to say, oh, judge, this officer is in fact in courtroom 305. There's 20 more minutes on that hearing. If we could schedule this hearing in half an hour, we'll be able to get it going.
Thank you, Eleni. Rachel.
Yes, good morning, everyone. My name is Rachel Echemendia. I am the counterpart at the Defender Association of Philadelphia, the co-chief of the municipal court unit. I primarily supervise preliminary hearings, which are essentially probable cause hearings in Philadelphia. The reason I bring up what I supervise is I think it's extremely relevant to this conversation, which is your preliminary hearing in Philadelphia is the first time a judge is hearing whether there is enough evidence to kind of hold you over for trial. Prior to being at the Defender Association, I've been there for about 10 years. I went to law school and come from different jurisdictions, so all my clinical experiences and my internships were in other places. And frankly, it is shocking kind of what goes on in Philadelphia, and I think the paper definitely covered that Philadelphia is an extremely unique system to practice in. I think that's part of what makes it kind of fun. It's a little bit of a rodeo sometimes, but it is extremely unique, and I think a lot of the uniqueness of the system contributes to some of these problems that we see in this paper. So specifically, and frankly, when I read this, I was not shocked at all at the numbers. I thought they actually might be low, if I'm being completely honest, because you will walk into any courtroom in the building at any point in time, and there could be a whole day where nothing on the list proceeds to go forward that day. And it could be anywhere from 10 to 20 trials or preliminary hearings, and just nothing is happening for the entire day. That's not a rare thing to happen in the criminal justice system. Usually you'll see a handful of cases go, but there really would never be a day where every single thing would be ready. Obviously, it's not solely attributable to failures to appear by anyone, but the fact that things don't move along in Philadelphia is not shocking to me at all, having practiced here for 10 years. It was very shocking to me when I first got here, because to me, I think justice should be served swiftly. It should be something that's happening, especially from the defense perspective. And I came from a jurisdiction where your preliminary hearing was within 72 hours of your arrest. You were seeing a judge. The judge was hearing the evidence, and if it wasn't ready for any reason, it was done. It was over.
What jurisdiction was that?
I would practice in Atlanta prior to this. So also shocking, because I came from the South, and I think Philadelphia has a reputation for being much more progressive. And frankly, that's not what I see on the day-to-day. So I think some of the things we need to think about when we're having this conversation, again, to the uniqueness of the Philadelphia courthouse, is that the public defenders and the district attorneys move, right? We are not in the same, as far as municipal court is concerned, and with rare exception, because I know you staff a room that's pretty consistent. We move. So one PD has a case, the next week, or whoever has the case next, is a different person. It's the same with the district attorney's office. So these cases get bounced around between attorneys from both sides. The judges, also municipal court with rare exception, also move. So the judge, frankly, is often hearing a case for the first time, whether they're hearing about the failures to appear or hearing the evidence on the case. They have no real background or understanding or investment in the case whatsoever. And there's all these moving parts of officers have to go to multiple rooms, witnesses probably sometimes have to go to a different courtroom than they were the last time. There's so much kind of commotion as far as movement that it kind of has created this, not kind of, just bluntly, has created a culture where there's just can be no accountability because there's no ownership from anyone or real investment for a lot of these cases. And so what that's lended to is that there's no enforcement mechanism legally, frankly, short of speedy trial rights, which I know the paper covered as well, to move these things along, right? You get a judge who sees a case as must be tried, which is kind of our made up thing that we use to try to move cases along on a second or a third listing. And you might get a judge, one listing who marks it must be tried. You might get a judge the next listing who's like, I don't do must be trieds, and it's gone, and the case keeps going. So you're getting preliminary hearings, which again are probable cause hearings in front of a judge that can take 3 weeks from when you get arrested to up to 6 months, some of them, because of these continuances. And so for me, obviously, as a defense attorney, that is extremely offensive to me. When I moved here, it was extremely offensive to me, and now it's just kind of a regular course of what happens in our courthouse. But particularly when you put that in with pretrial detention, because a lot of these cases, the allegations are extremely violent, you're looking at people being held on really high bail that are not eligible for release, that judges don't want to actually reduce the bail because of the allegations. But again, we're sitting months pre-trial with no one having, a judge not having never heard the allegations, the witness never having appeared in court, just waiting for eventually this case to get thrown out. And so for me, when we talk about the reality of the system, this is very much an inherent part of our practice in Philadelphia. It is shocking. It's no longer shocking to me, but I think it would be shocking to anyone who's never stepped foot in that courthouse to watch any list in any room at any given day. But I think, unfortunately, it's a huge just part of the culture we practice in. And I know we'll talk about solutions later, but I'm not sure if there's a way to fix it.
On that bleak note, moving on to Bill.
So that's why we put her in the middle. So my name is Bill Fritze. I am the chief of the Gun Violence Task Force. I've been with the District Attorney's Office in one capacity or another since 2006. I started out as a victim advocate, so I'm well aware of victim FTAs and the issues behind why they fail to appear. I will hold off on the police officer thing because I already figured out the solution for that. So we'll deal with that later.
Can't wait.
Rachel doesn't like it, but I figured it out. Yes, air tags. So Gun Violence Task Force is a joint operation with the Attorney General's office, and we are provided state agents to do investigations for us regarding straw purchasing and gang or group violence in the city, so very violent crime. We do not obviously have the problem with our agents of not showing up to court because they're the ones that investigate for us and come to court and testify. Within that, we are doing straw purchasing. So we are going out to the stores, finding out the people who've been purchasing those firearms for felons, and then arresting both the felon and the straw purchaser. Our cases flow through the system very quickly because we are using state agents. We're a small unit of 14 DAs, and we might have 30 agents that we're working with all the time. What we've done in the last few years, however, is use our agents to start investigating the violent crime in Philadelphia. And what that means is we start looking and using the power of the investigative grand jury, which is something that wasn't being done in Philadelphia to this extent. And so we work with the police department and look at the old cold cases and the high rates of crime that are occurring in certain areas. For instance, we've did a grand jury in South Philadelphia. We arrested at one point in time around 16 individuals who we knew were pulling the trigger for multiple homicides and multiple shootings. When you go and you arrest 16 people at once for over 30 incidents, it obviously makes a very quick impact in that neighborhood and kind of cools the violence down. But what it also does, it allows you as a DA and an investigator to try and put cases together, realizing that we are in a city where victims have an option because of the way the system works of coming to court or not. And so our job is to try and use as much electronic evidence, your cell phones, your text messages in your cell phones, your direct messages in your Instagram, your iCloud, your Google. That's what we spend 2 years building up to corroborate and also take the place of those victims or those witnesses who may not want to come to court and testify. And when we're being honest about the court system, we can talk about victims in this context. So one of the bar graphs that you saw was domestic violence, right? I'm going to take a guess that the domestic violence victims had prior cases and had also failed to appear before. And that's what we see with a lot of domestic violence cases, repeat over and over again. They are part of the system. They come into the system. They need help in that moment. But then life comes to them, right? And they realize they need someone to help support their children. They need financial support, whatever else. They know how the system works. So they know if I don't come to court, defendant will be released. My life will go back to the way it was. And that's not just for domestic violence victims, that's for victims of violent crime, that's for everything across the board because we have a lot of repeat offenders in Philadelphia. So if you are from a neighborhood and you were shot at or you were stabbed by someone you know from the neighborhood and you're afraid to come in and testify, the easiest thing that you can do to not have the heat from the neighborhood on you or any retaliation coming towards you is to not show up to court. And how many times do you not have to show up to court for a case to get kicked? 3 times. That's it. And if the DA can't find you and track you down, and my unit does use material witness petitions, we do use judge-only bench warrants, but your victim's still not going to want to necessarily participate. And if they never participated and never gave a statement to detectives or didn't sign the statement, those are all pitfalls along the way of how we're going to make a decision as to whether we're going to refile those charges and try 3 times again. So I'm not shocked by these numbers at all, but I think one of the questions we have to ask ourselves is when we see the violent crime numbers and we see the domestic violence numbers, does that play into our knowledge of why people understand that they know that they can kind of get away with this, right? They can not show up 3 times in a row. The DA's office is going to review. They're going to say this case isn't really all that solid to begin with, and then the case can go away. And then that repeats, right? Because maybe sometime the victim does retaliate, but the guy that was the defendant or the girl that was the defendant before doesn't show up because they didn't show up for them before. So that's what I see in our practice with a lot of the victim and witness FTA. And that's why we're trying to find different ways to put these cases up or find even different charges within that incident, right? So if it's a gunpoint robbery and the defendant is ineligible to carry a firearm, that's a felony of the 1st degree. So if I cannot get the victim to court, maybe I can get the charge held on the gun and still try and protect the community in some way, shape, or form. But that, I think, plays into the bigger dynamic of how the court system works and how we project how it works to the public, because they're all sitting there in the courtroom. They all know, and I've been yelled at multiple times from both sides when I've gotten, not from the public defender, but from people in the audience when I've gotten a 4th listing, right? And the audience starts screaming at me, "It's you! That must be tried. It was only supposed to be 3 times, right?" So it's well known in the community. And that is one of the reasons that we're using the investigative grand jury in this way, because you can compel witnesses to come forward and testify, where it's a little bit easier for us to get them in to try and suss out whether this case is going to be a quality case, whether we can get them to move forward and be comfortable and testify against people who are, many times very, very scary.
All right, we are now going to have a moderated conversation where I'll ask a couple of questions. We'll also be collecting questions from the audience, so please feel free to pass them down. And panelists, as we're talking, if you have something you want to add or a question you want to ask a co-panelist, just flag me and we'll try to have an organic conversation now. So let's continue on this theme, which is a really difficult one about victims of crime or complainants not showing up. And I want to turn back to you, Rachel, because I was a little surprised to hear you describe the FTA's phenomenon as negatively across the board as you did. I mean, from a defense perspective, is it ever a good thing that a complainant, a victim, as Bill said, has the option? Do you not think that victims ought to have that option to some extent in some way? Walk us through how you think about that.
I think my negativity is coming from a perspective of pretrial incarceration in these cases hanging on and lingering for far longer than they should in the system. So obviously, I think when you looked at the number of cases that were disposed of, and I think when I look at them this year, we're pretty much even higher as far as cases getting disposed of. It's a necessary part of the system that these cases get thrown out one way or the other for one reason or the other. Obviously, I think for me, maybe I'm just a pessimist just generally about the system at large. But when I think about cases that go on that have either, in my opinion, no business being a case, or we know this is going nowhere in the future, I think I was talking kind of systemically about just our practice. So another thing I want to kind of highlight as far as what happens when the case gets thrown out eventually because a witness necessarily doesn't appear.
Rachel, let me break in for just a sec. One of the audience members asked if you could clarify what the Defender Association does, and I'm sorry that was omitted. If that would be great.
They tell everyone there's only 3 listings. I'm kidding.
So the Defender Association is the public defender agency essentially in Philadelphia. We represent 70% of people that are arrested for crimes in Philadelphia. So we are the largest defense agency in the city. We're also the 4th biggest, I believe, in the country. So as far as volume in cases we're handling, we are the public defender's office. I know we aren't, the Defender Association isn't, the name is a little bit different, but we are the public defender agency. And I just want to say I very much appreciate being excluded from the private attorneys in this paper because we are there every single day and always generally try to be as ready as possible. So I just want to be very clear that we show up. So what I was saying is I think another part of the system that lends to what do we do and what's the solution? Yes, cases should get thrown out, and there are a number of cases that I think rightfully should be disposed of early on in the process if possible. But charging in Philadelphia is largely based on an individual reporting a crime, right? I'm going to exclude you because I think you guys do ample investigation, but largely it can just be you making a report to the police. There isn't generally a huge investigation process leading up to any corroboration of that, and then charges are instituted, and I think the paper said about 95% of arrests lead to formal charges in Philadelphia. The standard at a preliminary hearing, and the reason I'm talking about preliminary hearings is because I think a lot of, A, that's what I supervise, but B, that's where all the felony cases go. So for anything to be held for court to proceed to trial, you have to start at a preliminary hearing in Philadelphia. The standard is exceptionally low. The standard of proof at a preliminary hearing is all reasonable inferences in favor of the Commonwealth. Credibility is not an issue. Evidentiary issues, I apologize, like motion to suppress issues, suppression issues are not to be considered. And there are a number of evidentiary exceptions made just for preliminary hearings so that cases are easier to push through the system. The reason I bring that up is because when we talk about cases getting thrown out, you'll hear in court where a judge will hold a case for court and they'll say things like, I don't really have a choice because this is what the standard, but I don't see this case going anywhere. Or this was a really bad stop, right? And instead of identifying those cases early on and them having the benefit of things being able to be thrown out, they're moving forward in a system where they're getting held for court. That person has a case now for at least 6 to 8 more weeks, possibly longer. And the system is just, it's hard for me to say this. Yes, I want to circle back. Yes, obviously cases should be thrown out, but there are so many mechanisms in our system that make it so cases can go through when they probably shouldn't be, if I'm being totally honest. I mean, we have cases where there's dead complainants, where that case can never go anywhere. That just moved forward because of kind of the extremely low standard we're seeing for felony hearings. So yes, there are absolutely, I think our process and our numbers, there would be no world where we could process cases without the FTAs and without the withdrawal and without the disposition rates that we do, because we would just be completely overburdened and it would be an impossible system. And I think there are cases kind of to what,
Whatever.
Fritze, I didn't want to call him Fritze. I didn't have to. Is talking about with domestic violence, but I think on the flip side of that is you have cases where the complainant tells the cops in the paperwork, like, screw off, I don't want anything to do with this case. That person is still arrested and prosecuted in Philadelphia. So I think, obviously, I think there's probably an extreme that I'm talking about in that example, but we see it from both sides. There are cases just that have no business being cases in the first place, so my frustration as far as this being an issue at all is that some of them, I think we need a little bit more grace maybe on both sides and understanding to make this to even come to a solution. But obviously for me, when a case gets thrown out because someone doesn't fail to appear, it's because it either shouldn't have been a case in the first place or that's the right outcome because they need it to happen that way. And the Commonwealth always has the ability to refile charges when they want to if they're extremely passionate or have contact with the complainant.
Can I add something to that?
Please, go ahead.
I just kind of wanted to add on to what Rachel had said about how a lot of cases, the system expects cases to be disposed of through FTAs, and that is absolutely true. The way the courts list cases, it would be impossible. They expect witnesses not to show up. They expect these cases not to go forward because people aren't showing up, because they're listing 30 cases a day. It would be impossible. Everyone would be in court till midnight if we expected 30 preliminary hearings or 30 MC trials to go forward. The system is very reliant on those FTAs, and it also affects, our office's staffing. We have a lot of staffing down at the municipal court level, and it tapers up because we know we're going to weed out a lot of cases between the preliminary hearing when it moves up to felonies. The frustration for me is, it's just weeded out based on somebody not appearing, and this might be a very serious case, and now we need to find some other way to get that case going. So the fact that, that people are not showing up to court is just so, it's so bedrock to how Philadelphia even runs its practice. Sometimes I wonder how much, we even want to change, because it's part of the system that we need.
Let me make 2 observations that will lead us into another line of questions. One from the audience, one of you asked, can you speak to how courts are trauma? And I think that's an essential point to raise for a couple of reasons. One, it is likely a driving factor of FTAs to some extent. I don't know how many of you work in the Philadelphia Court of Common Pleas or how many of you have spent time there because of involvement in the system, but coming especially as an accused person or a victim or a witness can be an incredibly traumatic experience, which is a reason that people don't come. On the other hand, one of the consequences of FTAs is that cases drag out, and so the participants have to keep showing up, reliving that trauma and undergoing the same traumatic experience over and over. So that is absolutely a theme in this conversation. And it speaks to also the second observation I wanted to make, which is this study, this conversation, the comments you've heard so far really are about the criminal justice system, the way that it operates once you take a bird's eye view, which no one is charged with doing. Right? There is no actor in the system who, in fact, is charged with considering how all of the pieces fit together. And to some extent, there's a lot of really exciting, important topics in criminal justice and criminal justice reform. Administration is not exciting, but to some extent, some of the deepest pathologies in the system seem like problems of administration. Another audience member said, Eleni, your comment about ramen was very evocative. Are there systemic, administrative, technological solutions? So I'd love to turn the conversation to that question now. Notwithstanding Rachel's skepticism about the possibility of a systemic approach, do you guys see at least piecemeal steps that we here in Philadelphia could take, maybe that other jurisdictions already have taken, like in Atlanta, to use administrative solutions, technological solutions to make incremental improvements?
So I am kind of the tech person in the office. In the last year or so, we obtained a $20 million grant through the Gun Violence Task Force. And one of the first things that I did was I said, I am tired of using a paper file, especially when the Public Defender's Office does not use paper files because it's no longer 1950. So we have purchased for our office a new case management system, and it will bring us into this century. So no more paper files, contact with victims.
Sorry, when did you purchase the digital system?
We just purchased it. It's in the process of being built out into and working with the court system, the police evidence system, and it will all combine into one. So for one of the first times I think ever in the office, you'll be able to go to your computer and use one program. Right now at the district attorney's office, you're using 3 or 4 programs just to get your discovery alone, and that's separate from any system where you can contact your victim or witness and record that conversation. So this system has components to it that are going to be beneficial to everybody. It can send text messages to officers. It can send text messages to victims and witnesses. It will record all of that information. It will have portals that can flow back and forth between victims and witnesses. So I'm hoping that that increase in technology will help on that front. With the new police administration that's come in, they have also been focused on the FTA problem. And my unit in particular was asked, I guess during COVID, there was a backlog of firearms cases in the municipal court unit. And so at that time, the court came to us and asked us if we would establish a gun room. Essentially every case that involves a firearm, with the exclusion of shootings, homicides, and domestic violence, would go to one centralized courtroom in the courthouse. And so we said, sure, we'll take that on. We put one of our senior DAs from our unit in that room, and we bring in 2 municipal court DAs, and we sit there and we watch them, And we make sure that they're putting this case up, and we tell them there is no option except you have to have this hearing go up. The other thing that we did that caused us a little bit of problems was that we subpoenaed every single officer on the case. I got into a lot of trouble for that, and I just dealt with it. Because maybe you have 20 officers on one case, but they're all at that room at 8 o'clock in the morning. But a probable cause hearing it's a very low burden. So I don't need the person who actually recovered the gun. I can have the person who was standing next to him who saw him recover the gun, right? So we've been focused on finding a way to put those cases up. And what that has led to is an increase in the held for court rate. Even if that officer who recovered the gun failed to appear, his partner can testify, or 3 partners down can testify. We got a little pushback at first from the police department for subpoenaing so many officers, but then we weren't requiring them come back for a second or a third listing, right? So our list went from initially, I think when we started out during COVID, around 30 some cases a day for gun cases. We're now down to 15 cases a day. We actually 2 months ago had a 100% held for court rate that day. Every case was held for court. That's your low burden. But that made news, right? Like the municipal court bench was like, wow, every case went. Like no one had ever really done that. And the other thing that we do within my unit, because we're small and because we have the resources, is we track every single case. So if that officer FTAs, that goes into a spreadsheet. That spreadsheet is shared in real time with the police department, with their data people. And then that is then sent to whatever captain of whatever division. So for the gun cases right now, that's what's happening. But that is a lot of resources for one courtroom. You have 3 DAs in a municipal courtroom. You have a paralegal who's devoted to just inputting officer FTA. And we're not just saying officer FTA. We're trying to explain to the police department, like, yes, courts are recording it this way, but your officer had a funeral, he was sick, he had to pick up his children, right? Those are all different reasons for officer FTA. And when Eleni says that she's like reviewing those files to determine if an officer is, if we would refile, that's one of the things you look at. If an officer is sick, every single listing, that's a little bit of a red flag. But if there's like different things that happen in people's lives, we all know what happens, that's an easier refile. So our communication with the police department, I think on those, just on that room, should help better inform both sides. Because there is blame, right? We like to, well, the officer didn't show up, so we had to, well, why are you withdrawing all these cases? Well, your officer didn't show up. Well, my officer showed up. No, he didn't, and here you go. But we're working also within a system, within the police system itself, where if I need to send an officer a subpoena, we, from our office, send a notice to court attendants. Court attendants then puts it into a system from 1930. It is then printed out, given to the district, and then the district waits for the officer to show up and puts it in their mailbox or hands it to them, right? And most of the time, officer vacations are not in that system. It is a relic of the past that needs to be updated as well, but that is part of the system that we're working in. And then when we do refile a case and we say, yes, we think we can go forward, there's no scheduling mechanism to make sure that the officer's not on vacation at that point. So we can refile a case and an officer could be on vacation when we refile.
Who, like, is it Commissioner Bethel? Who needs to step in to fix the tech on the police side?
I believe he's taking a lead on all of it. I think it is being taken much more seriously now. I think before there was a lot of blame going back and forth. I think now there's been a more of a concentration on saying, these are the reasons for the failure to appear. It's not simply they failed to appear. Each one of these dates is an issue, right? And we got to figure out what our issue is on those dates.
I think we absolutely need, a prosecutor can only take this.
That was my question, how courts are trauma. And I'm so glad we in the community are here, because what y'all describing is a mess.
Yes.
I mean, the waste of resources. Oh my God, are you serious? And the violence in the community, there's no resources in the community. Go up and look at how people are living. And there's no talk about restorative or transitional justice.
I'm going to make you a deal.
Oh,
I'm going to let everybody hear you on
There is no talk of restorative or transitional justice. Brilliant attorney lawyer Angela Allen Bell in Louisiana wrote a brilliant paper talking about transitional justice. We're talking about reforms. This is not working. That is too much money and too many lives that's being ruined. Are you serious? 13, 30? I got 3 children. I ain't got no money to feed them. Then I got to take off work. My man locked up. I got beat last week. So now I got a domestic violence case. Then my son got a case. We can't continue like this. We have got to implement policy under restorative justice or transitional justice, because criminal justice, that's dead. You describing a dead system. And y'all part of a system, this is not working. We don't have 5 or 10 years.
You are anticipating my very next question and exactly where I wanted to take this conversation. So let's hear a bit more about administration, system level, boring bureaucracy, and then that's what I want to talk about, alternatives to resolving conflict that might not send quite so many cases into this system. Do you want to continue?
I also wanted to add that we need court buy-in for this. And by that, I mean, we need the courts to recognize that this is a scheduling problem that we all need to address. It can't be reliant just on the prosecutors and the defense giving everybody they need into the room. Like Bill had mentioned, we still use paper files. Our DAs put 30 files in a box in a cart and they drag it up Broad Street, and at some point it tips over in the middle of the road, and that's the day you become an ADA, I tell them, when your files are all over Broad Street and you're scrambling to get them back together. We're in the process of buying this new system, and I was meeting with the individual who was building the system, and I was mentioning the problems we had at the courts, and he said, you know, in Ohio, we built a system for the courts where it has all the cases listed, it has all the, you know, the parties listed. So whatever DA is needed, whatever judge is needed, whatever police officer, witness, and that computer system in the morning sends out the schedule saying, okay, so at 9 a.m. this officer is in this courtroom, at 10 a.m. they're needed in this courtroom, and that is a way where the courts could say, all right, we have all these people that we need on the same day at the same time, here's how we're gonna organize this, and that we can expect these officers or these witnesses to be in these rooms at these times. Because right now, all the officers are subpoenaed for either 8 or 9 a.m., and so if you're testifying at 8:15 in front of Judge Moss, but Judge Simmons has also called your case at 8:15, like now we have a problem. That, I believe, can be figured out through technology. There's no reason why we should all be on our cell phones texting each other, scrambling, saying, who has Officer Ross in the room? And if you have him, can you send him to me next? Like, that's absurd. It's 2024.
Great. So there's 2 themes in the questions that I'd like to address now. And first, before we get to the alternatives, on the more administrative side, there's a bunch of questions about police FTA and accountability mechanisms. So let's talk about that briefly. And then I really want to get to the broad theme that you raised, ma'am. This is a volume problem in significant part. Maybe this isn't the right way to resolve certain broad categories of cases that are now going into the system. And I don't think those cases are the cases your unit is dealing with, Bill. But domestic violence, for instance, this raises the question, is this system our best option to redress and deal with domestic violence? So we'll turn to that in just a minute. On police FTAs and police accountability, Lindsay, one of the questions is, can you track individual police FTA rates? So could you speak to that in our data? And then there's a couple of questions about potential accountability mechanisms. Go ahead.
Yeah, unfortunately we can't. So all we see is that example I showed where it'll say police officer failed to appear, police sick. We know that some police officer failed to appear, but as Bill said, they might subpoena 3 or 4, 20 police officers for a case. And so we can't, as of now, track individual FTAs. I think
you will.
We may be able to soon, so.
But we did, I mean, there were a limited number of cases. Do you want to explain
Sure,
that?
yeah. So because we know a police officer failed to appear and we have the subpoena data, we can see for the subset of cases where there's just one officer subpoenaed. And that is I actually forget what we found. Do you remember? Sorry.
I don't remember the details. It was a limited number of cases for which Lindsay, she did this analysis. There's cases where just one officer is subpoenaed for a certain number of cases. So for those officers, you can assess individual FTA rates. And there was a long tail, right? Most officer individual FTA rates weren't notable, but then there were sort of a handful of officers for whom the rates were excessive.
Yeah, well, and so for context, I don't know, people who've worked with law enforcement probably know this, but the main thing officers do is not make arrests. So the average, I think the median arrest in Philadelphia was 8 or 9 a year for an officer. So the average officer actually is not coming to court every single day, but then we do have like narcotics task force and some officers who make a ton of arrests, are involved in a ton of cases. So the range was very large. Some officers only need to come to court 2 to 8 times a year. Some are coming all the time and have this problem that Eleni mentioned of having to appear in multiple rooms and just, so we did see a wide range of FTA rates for officers.
And then as to accountability within the department, technically, I mean, department policy has been for a long time that appearing in court is sort of officially, pursuant to department policy, supposed to take precedence over all other officer responsibilities. But our understanding was that there has not been meaningful professional accountability within the department thus far. It sounds like that may be changing. Do you want to speak to that at all, Bill? No. Okay. All right. We don't know. We hope to have someone from the...
I am not from the police department, but there's been a lot more conversation than there has been in the past, and that has helped me, I think. So that's a positive, I would say.
All right. Let's turn to the sort of larger, super high-level question here. To the extent this conversation reflects dysfunction, a system that is radically overburdened, and large numbers of people, complainants, witnesses who aren't coming to court, does it tell us something about how the community perceives the value of this form of justice? And if so, should we be seeking alternatives? I'd love to hear your thoughts about domestic violence in particular. I think that's a particularly difficult area. And that is the area where the complainant FTA rates was the highest, something on the order of 70% of DV cases filed in Philadelphia criminal court involve a victim FTA. And that affects the dismissal rates. Do you remember, Lindsay, what the dismissal rate for DV cases was off the top of your head?
Cannot.
It's high.
70% FTA rate though, and
Yeah. All right. So, what do you think, Eleni? You prosecute these cases.
Well, so I agree with you that the system is broken, that there needs to be alternatives, and I think that as meaningful change happens, it cannot happen overnight, and it happens slowly. But that is one of the things that under DA Larry Krasner that we really do push is trying to say, okay, who are the individuals who are the drivers of violence? Who are the individuals who need to be prosecuted? Or are there other solutions with what we can do with this case? And that's why we very much expanded our diversion base. We do have a restorative justice program. It is run by Jody Dodd. It takes just about any case that does not involve a gun, Jody will review for restorative justice. But that's a very complex process that both the complainant and the defendant need to agree to it. But what I see with domestic violence is that what we have right now, it cannot continue because it does not work. These are heartbreaking cases, unlike some of the cases that Bill described where, if there's a, for example, the awful case where the biker smashed the window at Broad and Chestnut, broke the glass over that lady's children, that's all on video. Domestic violence cases are often not on video. This is a crime that happens within your home. This is usually something that we cannot prosecute if the complainant does not come forward to say what happens. There's often not a lot of corroboration, if any, and if somebody doesn't want to come forward and testify, then that case dies. And I think that when you look at the rate of individuals who do not come forward, who do not come to court, who do not come to court to the completion of the case, it is clear to us that it is broken, and it is clear to us that we need to think of alternatives to how we handle domestic violence cases that isn't just, prosecute. From my conversations with a lot of victims and survivors of domestic violence, that we do a lot of those cases in municipal court. Before that, I was a prosecutor in our family violence and sexual assault unit, so I've done these cases for many, many years. A lot of them call the police because in the moment they want to feel safe and they want the harm to stop. But then the police come, they remove the harm, and now you're home, and now you've had time to think about it, and now you need help with childcare, and you need help with the bills, and maybe you're getting calls from prison, maybe you're getting pressure from the family. You come to court the first time and you want to speak to the DA, but the results, there aren't a lot of options for you. The option is to get on the stand in front of the family and say what happened, and it's not going to resolve the case today, and it's not going to fix the problem today, and a lot of these individuals don't come back. And it's no surprise that they don't come back because we're not really giving them a lot of options. And that's another thing that is it's systematic wide. It's not something that I do not believe that is something that the prosecutor's office can fix on its own. I think all around we need other supports for our victims and survivors of domestic violence. We need just kind of wraparound services for them to figure out how to stop that harm from continuing, because the likelihood that the crime that took place is going to result in, jail forever is very, very minor, right? And that might not even be what the person wants. So if we're going to bring a victim in, we should be able to give them more options than we're going to get this case called for court, we're going to get this case found guilty. We should be able to give them a more holistic approach than what we've been giving them in the past.
Rachel, do you want to speak?
Sure. So I think I also agree with you that when you go into court and you see individuals who are having to pick about whether they are going to keep a job or stay in court for one reason or the other, from the defense and the victim side, when you see individuals, especially in DV, where there's cross complaints back and forth, where they have been on both sides, it's disgusting, if I'm being totally honest. You have people bringing kids to court and they have no option, and then you have judges that are getting upset that there's children crying in court. You have judges who will leave the bench for 2 hours to take a meeting and then expect everyone just sits there and not have to take care of their obligations. It's the domestic violence courtroom is extremely frustrating, I think, from everyone's angle, right? Like, that is not a room that is functioning in any way. And while I 100% agree that there has been a huge change as far as diversion and restorative justice over the last few years, there are also limitations to all of those programs, right? We have a domestic violence diversion program. It is for someone who has basically no record and it's misdemeanor charges. So if there's any allegations of any weapon being shown or used, that person is going to be ineligible for that program. And similar to other diversion programs, it's also subject to other limitations, right? Which is whether the referral's done in time, whether the district attorney agrees to it, and then often, which is the final block, which is we might all agree that something needs to go to diversion, the judge has the ultimate say. So we have judges sitting on the bench who are running some of these diversion programs who don't want certain cases before them for certain programs. So we have all these roadblocks. So even when we make a step forward and have opened all these programs and are trying to offer all these services, there's all these obstacles we have to overcome and hurdles that at the end of the day, it's easier for the case to just go away because no one wants buy-in into the system at some point. I think for domestic violence, what I also see is that a complaining witness will come in with expressed interest, whether they are saying it while they are testifying on the stand or before, about, I just want them to get help, I just want them in drug treatment, I just want this, and it is either held for court because they have testified, or because the district attorney doesn't have either, I don't want to say this for you, but like either doesn't have the discretion or doesn't have the ability to make a judgment call in that moment. I can't speak to that because I don't work for their side. But I think one thing that I think would very much improve across the board is having individuals who had buy-in and felt empowered to make decisions early on in cases, and this includes judges. For judges to have some ability to say, and we do have judges that do this and it always backfires on them, which is they'll stop a hearing in the middle and say, this is not what anyone wants. Like, we need to address this right now. There's a handful of those judges, and I think they always get pushed back because they make everyone's life harder to some extent. But it's always usually coming from a place of like doing the right thing. But if we had a system that wasn't so rigid and these standards weren't so strict, and we had people who I think felt comfortable making calls across the board, and that goes for my office too, right? Pushing for cases to be disposed of early, asking for more. I think it would just lead to more organic, justified outcomes, because right now we're just moving cases along and along, and we have cases in domestic violence that go on without a complaining witness that they put up with a police officer, that are going to be for months and months. And frankly, domestic violence has the highest, I think, besides guns, pretrial incarceration rate, because no one wants to let those individuals out of custody. And obviously I would say some of that I don't think is justified, but right, because the allegations are extremely serious. So we're talking about a courtroom where the court dates are usually about 2 months. Between court dates, you get at least 3 chances in domestic violence, usually for a preliminary hearing. The allegations are really bad, so no one will touch bail. So when we're talking about whether the complaining witness wants to prosecute or not, you're usually talking about someone being incarcerated about 4 to 6 months. That is being ripped from their home, whether they are a victim themselves at some point in the history of that relationship. So there's just so many factors that go into that specific room. And I think without complete buy-in from everyone, and I think that room is really hard for buy-in because I think we see it completely from 2 different angles on a lot of this. I don't know what the solution is, but I 100% agree with you that like it is absolutely not working. But for me, the only way we get to a point where it can work is that we have discretion and buy-in from every single person that's sitting in there. And when you have judges that rotate and everyone else is rotating, and some judges are really on board with like, oh, I'm stopping this hearing and we're figuring something out right now. And some judges are like, absolutely, I don't care if the person's not here, we're prosecuting, or we're like, I'm gonna hold this for court and move it forward, I'm never gonna address bail. You kind of just get so many different outcomes. It's just so unpredictable as it currently stands. One solution might be having a specific judge hearing domestic violence on a consistent basis, just so they can be more regular with the cases and the types of the nature of the charges and things that go into that room, because it is extremely nuanced and I think is totally different than so much of the rest of our practice. Mm-hmm. I'll pick the judge.
We're coming towards the end of the time. We still have 15 minutes, but we're standing between you and lunch. So we're not going to, I think we may end just a bit early, but not yet. Before we end, I'm so glad that we are having this conversation. Because for those of you who work in the courthouse, if you've ever been in the courthouse, as we wrote in the paper, in FTAs, it's so fundamental to how the system is operating. You don't even realize it. It's just the air you breathe. Mm-hmm. And yet it is an aspect of the system that really has not been part of the policy or the academic conversation, aside from defendant FTAs and bail. So it's great to be talking about. I think it does raise a lot of these deep questions about the goals of the system, the pathologies of the system. We've been talking about high-level, large-scale changes that we need to figure out how to think about and make better technology, better scheduling, better administration, better accountability mechanisms for cases, alternatives to criminal prosecution for whole categories of interpersonal and community conflict. What I'd like to ask you all now is, on a smaller scale, what can each individual in the room, I imagine a lot of you guys are lawyers, some of you are academics, some of you are law students, what can we sitting in this room do on an individual basis in the next year to contribute to moving things in the right direction? Are there specific things that individual lawyers, individual academics, individual community members can do?
Go to court. No, I'm serious. Our courtrooms are empty. Nobody's watching what's going on. Go and see what's happening. I work in the system, right? I am part and parcel of the trauma, right? I either cause it for some people or I try and remedy it for others. But we are operating in a system that was built, right? So that's what we do. You're the public. you vote for the judges, you see how these courtrooms operate. You can sit there and watch and say, this could be done better. This could be done this way. Why is this type of case even in the system, right? Listen to the arguments of the attorneys. Why are we arguing on certain cases that we want people incarcerated versus why we don't want people incarcerated? Is there a balancing mechanism that other people outside of the system can do? I don't think that you can't sit outside of the courthouse and say there's problems there, because it's easy enough. There's four major different parties operating within there. There's the court system, there's the police department, there's Defenders Association, there's the district attorneys, and we are all our own organizations, and we are all trying, but not all of us all agree all the time. But if you go to court and you actually see what's happening, when we're talking about trauma and watching people go through this, I think that is eye-opening, and I think that is what is required. Is the community needs to come back into the courtroom.
I was going to say, you kind of touched on it, vote in a meaningful way. I think often people don't want to vote on judges because they don't really know the judge, or they vote just kind of down the party line and everyone runs as a Democrat for judge in Philadelphia. So I think I say that because it really does matter. I think we all think about like these judges moving around, but the impact each judge has on the bench and the decisions they're making have not only just like individualized decision or impact on the people that appear before them across the board, but can lead to policy change, can lead to so many things, and it takes a judge willing to start a program or something like that can really be the things we're talking about accomplishing. And it really matters. So I would say go into the courthouse, ask if there's a judge on the ballot, go ask where they're sitting and go watch their room and make it the decision for yourself. I think the judge elections are interesting because they often are predetermined based on like the ballot spot, I think. So endorsements, ballot spots, things like that, but having individuals kind of actually vote in a meaningful way and know the information, I think would make all the difference, because it's, I think, the very limited impact we could have at this point for all of you to kind of what to do over the next few years.
I'm in complete agreement. Vote, right? It is our judicial elections are so important. It's something that nobody pays attention to. I have also sometimes sat in these courtrooms and wondered, like, people must not know what's going on in here because this is bananas. So yes, if you are an academic and also a journalist, or if you are an academic and you have a platform and you want to come and watch how those courtrooms are running, please come and watch those courtrooms, because I think you'll be appalled. But I would also say that if you have a level of expertise in anything that we were talking about today, if you're watching this, remotely, and you are an expert on restorative justice as it applies to domestic violence, please reach out. Speaking for the district attorney's office, we are always interested in learning and growing. We are always interested in speaking to the experts from other jurisdictions and from other areas. So if you have expertise on anything that we brought up today, being systems or organization, or diversionary programs, restorative justice, any of that, the DA's office should be a function of the community, and we want to be a function of the community. So please reach out to me and I will connect you with the right person in our office to speak with.
Lindsay, any thought?
I think they got it.
Lindsay has gone to court as an academic. She has been embedded with the DA's office for the last 2 or 3 years, which is something that's extraordinarily rare among criminologists and legal scholars, and I think incredibly valuable. So by her example, that is something that academics can do. Please join me in thanking this wonderful panel.
Thank you to all of you. One of my favorite quotes comes from the organizational psychologist Edwards Deming, who says, "Without data, you're just another guy with an opinion." And I think the first step to change is people agreeing on what the problem is. And you guys, with the data and these comments, have really helped us understand the nature of the problem. And I think, again, in our title of this, from anguish to action, there's knowing knowing where to start solving the problem allows us to take action. Believing and agreeing on the problem allows us to take action. So thank you for that, because the complexity of this problem cannot be an excuse for not taking action to solve it. So